Well, hey, howdy, hi. Happy Monday. Hope everybody had a great weekend. I know I did. I had a great live with Coolest Reviews last night. We talked about the hatchet-wielding hitchhiker case. It was very interesting. I had a great time. Thanks for being there, Coolest Reviews. Hi, Sam. Hi, Diane. Hey, Coolest. How's everybody doing tonight? Well, we have a lot to talk about. Today was an interesting day as far as court and trials go, or trials that didn't happen, actually. There was a lot of stuff that happened. Oh, cripes, I didn't mean to push that. There's a lot of stuff that happened today. So we're going to talk about it all. Let's see. Let me find what I'm looking for right quick. It's not what I want. Let me go to Schmieda's. Schmieda's out here making premieres and not telling anybody, but I'm going to use hers tonight. I usually don't do this without asking. Hopefully she's okay with that. Okay, so Aiden was supposed to go. His trial was supposed to start today. It was supposed to be the jury selection started today. So before they could do all of that, they were getting it, going and whatnot. Surprise! Aiden has decided to plead guilty, which I'm want to listen to this plea again. And the reason why is because I thought I caught his attorney saying something, and I'm not exactly sure if she said it or not. So, hey, Corkies. Corky, I'm not sure if she said it or not. So I'm not going to say what I think she said. But I just want to listen to it again. So, yeah, we're going to listen to him plead guilty, and then we will get over to the Murdaugh trial, because that one was full of stuff today. And so, but before we even get started on that.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash! Yeah.
Make sure you've given your girl a thumbs up or a thumbs down if you just want to see what the thumbs down does. It's up to you. I believe in freedom of choice, and if that choice includes giving me a thumbs down, it's cool. I can take it. So yeah, that's what we're going to do first. We're going to talk a little bit about Aiden Fucci, and then we are going to get right into Murdaugh, because there's a lot to go over today with Murdaugh. Okay, ready? Here we go. Let me also, before I do that, let me go ahead and drop Schmieda's link in the chat real quick. Before I forget. All right. I'm still, all right. There you go. There's Schmieda's link. Okay. Make this bigger. And go.
We are here to begin our jury selection process. However, it's come to my attention that there may be a change of circumstances. Ms. Peoples, is that correct?
Yes, sir.
Okay.
Yes, Your Honor.
If you and your client can go ahead and approach the podium. Doug, if you want to approach the bar. Ms. Peoples?
Your Honor, on behalf of Aiden Fucci, we enter a change of plea at this time, and entering a guilty plea as charged.
And
I have it as loud as it'll go.
This is not a negotiated plea, is that correct?
Your Honor, we have presented several defense offers, and they've all been rejected by the state.
Hang on, I'll
So
just
it will be a straight plea to the
switch.
court.
Yes, Your Honor.
State, can you make sure that you state for the record the
All right, hold on. I'll find a different stream, but still go sub to Shmita. All right, hold on. Hold on, now I gotta find it again. Here it is. I think it's just the audio from the court, but I did find one with closed captions, so we should be good. All right. All right, here we go.
in our jury selection process. However, it's come to my attention that there may be a change of circumstances.
Hey, Samantha, it's good to see you.
Is that correct?
Yes,
Okay.
Yes, Your Honor.
If you and your client can go ahead and approach.
Yeah,
the
it's the
podium.
audio of the court. There's nothing I can do about it. Sorry.
All right, Ms. Peoples?
Your Honor, on behalf of Aiden Fucci, we enter a change of plea at this time, and entering a guilty plea as charged.
And this is a straight plea to the court. In other words, this is not a negotiated plea, is that correct?
Your Honor, we have presented several defense offers, and they've all been rejected by the state.
So it would be a straight plea to the court.
Yes, Your Honor.
State, can you make sure that you state for the record the possible.
Hey,
penalty
Tia.
that he is facing if he has a straight plea?
Yes, Your Honor, he's facing a possible sentence of life imprisonment. The mandatory minimum would be 40 years. So similar to after trial, the range of exposure is 40 to life. He will be entitled to a review hearing after 25 years of serving any prison sentence. Your Honor.
Ms. Peoples, have you had sufficient time to talk with your client about this decision?
Yes, Your Honor.
In addition, are his parents aware of this disposition, proposed plea?
Both parents, yes, Your Honor.
And they've had an opportunity to consult with you as well as Mr. Fucci?
Yes, Your Honor.
Are there any other matters we need to address at this time before I place Mr. Fucci on the road?
No, sir.
All right, Mr. Fucci, if you could step over and speak into that, if you could address that microphone. Sir, if you'll raise your right hand, you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, sir.
Okay, so I think I did hear what I thought I heard. Okay, so when I listened to this morning, I was doing my morning chores, and so I wasn't sure if I heard correctly because I had other stuff, going on in the background or whatever. I did hear this. So now I'm understanding what's happened here. I think that Aiden has at some point intended to plead guilty to this the whole time. But I don't understand why they needed to wait until today. He could have just pled. So I don't know why why his attorney waited until today to do it. Obviously they offered plea deals and whatnot, and well, not really whatnot, but straight plea deals, and they were rejected by the state, which I understand why the state rejected it. They felt like they had a strong case, and in the end, basically, he's facing 40. Hey, Tony, 40 years to life. And he will be eligible to have his sentence and case reviewed after 25 years. So it really was subpar. He should have gone for the catatonic yes, no, that Staven presented. Why he didn't, I don't know, but yeah, so he's about to plead guilty. The judge is gonna, make sure he understands all the things that he can go for, that he can have a trial. He has a right to, address any of the evidence, put any of his own evidence on, yada, yada, yada. So basically I'm just going to skip forward so we can hear him plead guilty, because to be honest with you, he's got his, the judge did a great job explaining to him his rights. Yeah.
Please state your name.
Aiden Fucci.
Mr. Fucci, how old are you, sir?
16.
How far did you go in school?
To 8th grade.
Are you able to read, write, speak, and understand the English?
I did,
Yes,
Crystal,
Your Honor.
yes.
Are you under the influence of any medication, drugs, or alcohol right now?
Yes, sir. My medication, but
What type of medication are you taking?
Rimruns, lithium, and Suprexa.
Is that medication prescribed by a physician?
Yes, sir.
And does that medication assist you in your ability to understand what's happening and going on around you?
Yes, sir.
Have you taken that medication today as prescribed by your physician?
Last night, sir.
Last night, is that when you were scheduled to take it?
Yes, sir.
All right. And is it in any way, shape, or form affecting your ability to understand what's going on here this morning?
No, Your Honor.
Do you feel clear-headed and clear-minded about what's going on here today?
Yes, Your Honor.
Have you ever been diagnosed with a mental health condition that could affect your ability to understand and comprehend what's going on today?
No, I don't believe so.
Your attorney has informed me that you'd like to enter a plea of guilty to the charge of first-degree murder. That is a sentence that is a crime which is punishable by up to life in prison. The minimum sentence that the court could impose would be 40 years in prison. You just heard the state outline that range. Do you understand the range of possible penalties that you're facing if you enter this plea today?
Yes, Your Honor.
You understand that the minimum sentence that this court could impose for you would be 40 years in prison. You understand that?
Hey, allegedly, what are you doing here, babe? I thought you had a life.
Life in prison. Do you understand that as well?
I do, Your Honor.
And the way that this works is if the court were to sentence you to 40 years to life.
That was a fun roast, wasn't it, Tony?
Review sentence of that sentence in 25 years. At that point, another body would then come back and review what we're doing here today, and they would look at that sentence and determine whether or not they should change that sentence. However, that's no guarantee as to what they're going to do. That's just something the statute that requires another body to review this court sentence in 25 years. Do you understand that as well?
Yes, Your Honor.
Okay, all right. What time is yours for, Brittany? And I'll come visit yours after I'm done here.
If you do this,
No, sir.
no one's said, hey, if you enter this plea today, the judge might, go lighter on you or anything like that. No one's promised you anything like that, have they?
No, sir.
You understand, again, I could give you 40 years up to life in prison.
Yes, I do.
You understand that today, we're here for jury selection. So we actually have members of St. Johns County who have reported to the courthouse today downstairs. They're actually waiting for us right now. And we were going to begin to select a jury to conduct a
Okay,
trial.
babe, I'll be done by then.
You
I'll be done by
understand
then.
you have the right
I'll
to
come
that
and
jury
see you.
trial?
I promise. Thank you for coming to support. I appreciate that.
Your attorney had filed a motion, and we had had a hearing a few weeks ago, I guess, where she had, the state had requested a 6-person jury, and your attorney requested a 12-person jury. Do you recall that hearing that we had on that?
Yes, sir.
You also understand that right now your attorney has filed a motion to an appellate court, which is kind of a higher court above this court. Their responsibility is to review all of the decisions that go on here. And right now, she's filed that appeal as to whether or not you were entitled to a 6-person or a 12-person jury. You familiar with all that?
Yes, Your Honor.
Did she?
Fabuloso. I love
The
Fabuloso.
fact that by entering this plea today, you're kind of taking away that issue. In other words.
Oh, thank you, Brittany. I appreciate that.
Yes, sir, I understand.
I really do. Thank you very much.
That's going to go away. You understand that as well?
Yes, sir.
Yeah, everything's going to go away, and they're going to set a sentencing date, which I think is February or March something. I can't remember now. So now I'm stuck watching.
Has anyone promised you?
Can't
anything
even
in
skip
exchange
for.
your plea?
Hey,
I have a document here. It's called a plea form. It has
look
the
at
same
that.
word
Thank
as
you,
your name
Tony.
or case number. On the second page of this document, above the word defendant is a signature. Can you see that signature I'm pointing to? You have
Yes,
a
sir.
copy of it in front of you as well, is that right? Is that your signature?
Yes, sir.
And by signing this document, are you indicating to me that you've read this document?
Yes, sir, I read it.
In addition to reading it, did you discuss it and talk about everything that's on it with your attorney?
I did.
Did she answer?
Wait. I just realized something. Oh, thank you, Brittany. Thank you so much. Welcome to the Fall Club. Thank you very much. I just realized what he said. Did y'all catch that? It was earlier. He said he's only gone to the 8th grade, but homeboy's been in jail for 2 years. I know they have school in the jail. Maybe it's because he's being held at a grown-up detention center, because that is where he is. He is he is in an adult jail, okay, but he is being held with other juveniles who are charged as adults. So he's not in there with grown-ups, with adults. He's being housed with juveniles, but maybe they don't have school because he's in an adult jail. I don't have to look into that. I don't know how Florida does it. All right, here we go. I don't know what's going on with his attorney over here, because she looks defeated, and I'm not exactly sure what's going on here.
Any and all questions about everything that's contained on this document?
Yes, sir.
There's a number of rights that you're giving up. I've already talked about them a little bit, but I want to talk about them again with you, okay? You understand again that you have the right to a jury trial. During that trial, you're entitled to be represented by an attorney.
Oh boy.
You've got attorneys who are appointed to represent you.
Crystal.
And with you throughout
Yeah,
the
this
trial.
kid.
You have the right to compel witnesses to come in and testify on your behalf.
Yeah.
You could have testified during that trial.
You sure could have.
You could have presented evidence.
But you
during that
didn't,
trial.
and you pled
You
guilty.
know, all of those.
Yep, you're giving them all up. Yep.
Not provide a fair and impartial jury for you. Once you understand that now, that we're going to provide it. Have you had sufficient time to discuss?
Yeah, he's had plenty of time.
They did.
Do you need, is your being deported from the United States?
Yes, sir.
State, have you supplied the defense all of the discovery in this case?
Yes, Your Honor.
Are you aware of any physical evidence that can be tested for DNA that might exonerate this defendant?
No, Your Honor.
Ms. Peoples, have you had sufficient time to review all the discovery and discuss it with your client?
Yes, Your Honor.
Are you aware of any physical evidence that can be tested for DNA that might exonerate your client?
No, sir.
Statement of a factual basis, please.
Yes, Your Honor.
And we don't want to hear all this. It's so sad. I can't.
You are prepared and alert, and you understand the nature of the charges and the consequences of your plea.
I do.
We need to pass this matter off for a sentencing hearing. I know that this.
Yeah, he does have a bit of a different accent. You're right, Brittany.
Let's talk a little bit about what we need to do before we get to sentencing. So we hear from the state.
Yes, sir. I think if we want to state a discovery deadline where both parties have to disclose any additional evidence for purpose of sentencing, any witnesses that have not already been disclosed, and then from there, set a trial in February, if you're on the right, and then probably pick a date sometime in February once we exchange those weapons.
Pick a date for the sentencing out in March or April. Is that what you're suggesting?
Yes, Your Honor.
Ms. Peoples, does that schedule work for you?
Yes, sir.
How long will both sides need to compile a list of witnesses to for the sentencing hearing?
I believe 10 days would be sufficient, Your Honor.
All right, so 10 days from today, both sides will tender a witness list and any other discovery that they intend to utilize. Obviously, if there are letters of impact statements, things of that nature, I would expect those. But if it's anything of evidentiary value, that needs to be.
Hey, Seth, good to see you. I think you're right,
Today.
Brittany,
I'm
honestly.
also going to order a pre-sentence investigation. Ms. Peoples, are you requesting that as
It
well?
would,
Yes, sir.
And
yes,
a
Tia, it
pre-examination
is.
report, I believe you would be entitled to that, so we're going to. order
Oh,
both of
Shmita
those
out here
reports.
gifting memberships. Thank you, Shmita. And Shannon, you got one.
Your Honor, just a special request with that order that if the court could note to the meeting DJJ and to the, I believe it would be the sheriff's office, that defense counsel wants to be present for those interviews.
I will absolutely notify them as well that you should be present for those interviews. Mr. Fucci, your attorneys are going to be present with you, but there will be, there's going to be a couple of reports that are going to be compiled for the court there.
Yeah.
State on the state's behalf, I would say reserve one for us, whatever.
Okay, well, we'll set aside, we'll find 2 days. You all tell me when you both will be ready, and then we will select those 2 days. And then any hearings or any motions that we need to address on February 23rd, we can address those at that time as well. And I believe that covers everything.
Mr. Fucci.
Mr. Fucci, when I asked you about whether or not you read it, your attorney actually read the plea form to you, is that right?
Yes, sir.
And she went over all those rights that I went over with you as well?
Yes, sir.
And she again answered any and all questions about everything that's contained on that document for you.
She did.
And your parents were also present during that conversation as well? Were they present as well?
No, it was a separate conversation with the parents. Your Honor.
Okay.
And Mr. Fucci just wanted to make a short statement.
I just want to say I plead not guilty. That I'm sorry for the Bailey family and my family.
Okay.
He just pled not, wait.
Okay. I'm sure
Wait.
you'll get an opportunity, obviously, at sentencing here.
Wait. He just pled not guilty. What happened? What happened? They're not going to correct him, you guys. They just let him. Jeez.
Speak again at that time, okay?
Yes, sir.
All right, any other matters we need to address? Anything else from the defense?
No, Your Honor.
No, sir.
All right, well, we're adjourned. We'll see you back here February 23rd at 9 a.m.
All right. See you February 23rd. All right. Now, on to new business. Please hold while I search real quick. So let me tell you what happened today in the Murdaugh trial. Yikes on all the bikes. Okay, so what we really have going on here is a trial within a trial, but thankfully that's over now. Okay. So what we're going to start with first is the mini trial. Okay. So this morning, the state is putting on witnesses. Okay. And it in camera, so behind closed doors, outside of the jury's presence. Hey, Jenny. Yeah, I'm not I maybe it doesn't matter what you say; it matters what you sign your name to. And he did sign a guilty plea, so saying he's not guilty, I'm not sure how that, but I'm pretty sure. Hey, Tammy, I'm pretty sure it matters where you put your signature. So while I am looking for what I want to play next. Oh, thank you, JB. Britt, that was so sweet of you. All right. So for everybody new coming in, this is for y'all.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash. Yeah.
Cement Shoes made that. I mean, not Cement Shoes. Coolest Reviews made that for me. I love it. It's my fave. Okay. So basically what happened today is the state is going to continue to put on more witnesses to produce clear and convincing evidence that that these specific witnesses should be allowed to testify to Alec Murdaugh's financial crimes as to motive. Okay. They aren't intended to, the jury isn't to infer that he has a propensity because he may have committed some financial crimes. That doesn't make him more likely to have committed murder. They're only using it to prove motive if the judge, decides that that's what they can do, which, spoiler alert, yes, the judge decided that's what he ruled on. They're going to be allowed to put on witnesses to speak about the financial crimes, but only it's limited to questions surrounding motive. And hey, Amelia Sparkles. Hey, Kate Does Crime. Yes, it was. Get off the phone, Kate. I know you can't even hear what I'm saying. Somebody put in chat, please, to tell Kate to get off the phone so she can hear. All right. So what had happened this morning was the state called Mr. Tinsley. All right. I think it's Tinsley. It might be Tinsley, but I think Tinsley is right. Regardless, he is the attorney who represented Mallory Beach's estate, her family, in the boat crash civil suit. And she's doing great, Seth. Thank you for asking, babe. Excuse me. And Mr. This attorney, just until that he says his name, so I'm thinking, because I keep second guessing myself about how to pronounce his name. But anyway, yes, allegedly, poor Mallory. And remember how I kept saying that people were wondering why his financial crimes, his alleged financial crimes, because remember, he's not been convicted of them yet. So I have to use the word alleged. That his alleged financial crimes, they didn't understand how it explained murder. Why was that a motive? Why would he kill Maggie and Paul? Well, I think that it's hard for people to understand because he financially didn't actually gain anything. Like, he did not stand to inherit money, right? There wasn't a life insurance, etc., right? So typically when the motive is money, most of the time people actually gain money, right? Well, that's not what happened here. It was never about actually gaining money. It was about buying time. But the lawyer for for Mallory Beach's family put it so succinctly that I am not even going to say anything. It's Tinsley. Okay, Tinsley. That's what I thought. I thought I was saying it right. Tinsley. I'm not even going to say anything. I'm just going to let him tell y'all what's what, because he put it perfectly. He had an excellent metaphor and everything. And y'all, maybe it's an analogy. I think it was an analogy. I love a metaphor and an analogy. All right, so let me share my screen and we're going to get right into it. And I'm telling you right now, this was, I think, probably the worst day that the defense has had since his team opened the door to this type of questioning in the first place. All right, let me add it to the stream now. All right, and now I have to turn my stuff down because, oh, you're welcome. You're absolutely welcome, Amelia. Yeah, because it's a lot, and especially when there is a trial inside of a trial. Like, there's literally 2 trials going on right now. And I know, Tony. It's hard. All of this is hard. I Oh, Seth, you're really sweet about. Thank you very much. They have moved, and I maybe you missed the update. You must have missed the update. So for anybody that's wondering what Seth is talking about, Olivia needed a stem cell transplant, okay, because she has ILD. But last Monday, she met with the transplant counselors, and they've reviewed her medical records and all of her current testing because she was in the hospital in between, well, right before Christmas with pneumonia. So she had a whole bunch of tests run then too. So they said that they do not think that Olivia needs a stem cell transplant at this time, that her ILD is not progressing. It hasn't gotten any worse. It's staying just right where it is. She is good and stable on all of her medications. And so I'm so over the moon about that. And they're going to do a CAT scan, I believe, at the end of February or beginning of March, and reevaluate and reassess, because in order for her to have the stem cell transplant, it's very taxing. She'll have to have chemotherapy. It's hard, and she's just 2 years old. And so if she's good right now and doesn't need it, then awesome. So yeah, everything is going so, I'm over the moon. Everything is going so well for my little Olivia chicken nugget pot pie. Good to see everybody coming in. Thank you so much. All right, are y'all ready? Because Mr. Tinsley finna be on. Hey, Mallory, good to see you. I'm having a hard time, like my chat's not working good. Okay, there we go. All right. So, hey, Candace, good to see you. Everybody coming in. All right, so here we go. Wait, did I even put it on? Yeah, it's on. All right, here we go. For reals now. No more talking. And I'm sorry there's no closed captioning. All right, here we go. Thank you, Claire. Welcome. Good to have you.
Good morning. You ready to proceed? All right, may proceed.
I believe we're again here in camera matters, and the state would call Mark Tinsley to the stand.
That seems a little loud for me. It is, Brittany. It is. Everybody's prayers, everybody's good juju, good vibes.
Take a
Just
seat and
all
get
the
your
positive
seat. State your name
energy,
again for the record.
even the
Spell your last
financial
name.
support. I mean, honestly, we could not have done it without you guys. Really, we couldn't. And my family and I thank you from the bottom of my heart. I cannot thank you all enough. I just can't.
My name is Mark Tinsley.
What's up, Mark? Mark about to lay it down, y'all. He about to break it all the way down. Hey, Angela, good to see you,
Mr.
babe.
Tinsley, how you doing today?
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would where you testify before the jury. You understand that?
Hey, Elizabeth.
I do want to, though, kind of
you.
move quickly some of the subject matter that the state proposes to put before the jury. But very quickly, if you would, just quickly tell us what you do for a living and what kind of practice that you have.
My name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
Of course it is, Tia.
All right.
Bless
and how long have you been practicing in Allendale?
Since 2000, so 22, 23 years.
You have a statewide practice, or is it primarily?
To the extent I want it statewide. I mean, I handle cases statewide if I'm inclined to handle those.
Okay.
Primarily focused in the 14th Circuit, is that fair?
14th and the 1st.
And the 1st. Okay. You know the defendant, Alec Murdaugh?
I do.
And how did you get to know
Um, he practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came to Allendale.
him? And do you know other lawyers in the what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with over the years?
Yes.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately.
And do you represent the Beach family in the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alec Murdaugh. Is that
I did.
correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, when this case started.
Mr. Waters, my recollection is that I sued Alec Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdaugh Family Trust, which owned the property where.
Let me just say this before we get into it. Oh, I loved watching The Lawyer's Lawyer. Oh, thank you, LFT. Thank you so much. I appreciate that. That's so sweet. Thank you. Thank you very much. I love watching the lawyers do the lawyering. That is why is this doing this? That is what I love about the trials, is the lawyers lawyering. But let me just say, the MVPs of this trial so far have been Jeannie, the accountant, Mr. Tinsley here, and the caretaker. And these so far, well, and also Rogan. I got to give it up to Rogan because he did identify Alec Murdaugh's voice on the phone when he was on a telephone call with Paul, when they were coordinating what was going on with Chase and the dog. And, he was trying to do the FaceTime, but it wouldn't go through. So he decided to do the video. Yeah. See, that's important. That is important. All right, here we go.
The boat was launched from, and we believe that could have been some drinking that went on there.
Oh, thank you.
I'm not
Thank you
100%
so
certain in the
much.
first lawsuit if I sued
appreciate
Buster
that
Murdaugh,
so much.
which
Thank
is
you.
Alec's son. But I think those were the defendants initially.
Okay.
And maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, and well, let me ask you this. Did your client, Renee Beach, have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
Now, can you explain that to the court, please?
She
So shady, Mrs.
she
W.
wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday. So the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alec's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay.
I would imagine. I'd be upset by that too.
Did she, in your discussions with her, did she give you any particular instructions about proceeding forward in this particular case as part and based on that experience?
No. Nobody really gives me instructions.
I understand.
No, I feel you, Mr. Tinsley. Nobody gives me instructions.
Not long after you get involved in this
Mallory.
case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
My recollection is within the week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the
Yes,
boat
sir.
crash
Cement
as
shoes.
Alec's
Yes,
personal
sir.
lawyer brought me all of Alec's
I
insurance
gotta
policies.
let my
and so
dog
I
out.
reviewed
I'll
them
be
at that
right
time,
back.
before I
But I'll
filed the
be a
lawsuit.
cat, so I
And
can
what was the
still.
purpose of you reviewing those policies?
You know, in a civil case, the only thing that we can do to try to, under the law, make a
Yes.
party whole is recover
They
money
did.
damages. And oftentimes, when
They
we
did.
are
And it was wrong.
drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I
All right,
wanted
for reals, I'll
the
be right back.
coverage.
I gotta let the dog out,
And-
but I'll be in
and
the chat.
beyond
so I
that,
can still hear
sometimes,
everything.
like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is. Many times insurance companies can be leveraged to pay their insurance out, to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right, and when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat and 2 other boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court, why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was the Satterfield matter, and that it was Nautilus and I think Lloyd's of London, and they would not renew the policy, and so he had to then seek other coverage, and what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusion. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge. Is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular. And so, you know, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alec's attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing when insurance coverage was available?
Always.
And that was consistent all the way through, is that correct?
All the way through.
Were you making substantial demands to the defense that Alec pay a substantial recovery personally?
I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that somebody would willingly take to go through what they've gone through. But if you were asking a lawyer who does civil work, was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment, did that come as a bit of or did the defense express to you surprise that you were seeking a personal recovery from Alec rather than just simply trying to access what insurance coverage he had?
Yeah, some people did.
All right, I got to pause here for fair use and commentary, but can we just stop for a second and let the fact that this man, Alex Murdaugh, was making money hand over fist, allegedly stealing from his clients. Well, he did steal from the Satterfields. That is fact. Anyway, not only that, but he was underinsured. And he tried to, I don't know what the right word is. He was shysty when it came to the insurance that he did have, that it was for commercial use. Like this fool went to school to become a lawyer, right? Studied, got his Juris Doctorate, had to take and pass the bar exam, which is not an easy feat. And yet I don't even know another word, and I hope I don't offend anybody with this language, but he's just out here fucking around, not even doing things close to the right way. Every time they put on another witness for his financial stuff, it just gets worse. It gets worse. Gross. All right, here we go.
John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work?
I'm also just going to speed him up just a scotch because we have quite a lot to get through tonight. I'm just going to put him up to 1.25. Okay. All right, here we go. Wait, let me get that away. All right.
It used to be called the Trial Lawyers Conference. But yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah.
He did, Mrs.
I
O.
think
Really
not
did.
100%. It was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alec sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything, I'm not going to do everything, you're wrong. You need to settle this case."
Okay. And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about, what is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me and sort of bully me into backing off.
Was there a mediation in September of 2019?
There was. No, September of 20.
Before we get there, we move into early March 2020, and we probably all know the answer to this. But what happened in March of 2020 that kind of changed the world?
COVID, the court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement that was at the scene early on, and then ultimately when everything finally shut down, I'm not sure if it's May or April when
he should, Seth. He absolutely
we were sort of confined
should.
to our offices.
Did you,
You
during
are
the course
sure
of
right
COVID,
about that,
take the
Diane.
opportunity
You're
to
right.
sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
And were the results very favorable for your client and not favorable for Alec?
They were.
Did you ultimately communicate that fact to the defense?
I did.
All right, I got to pause for some commentary here and fair use. See, this part I found incredibly fascinating because I think on the part of this attorney, it was brilliant to do sort of a mock trial to gauge what he would be looking at in a possible trial scenario and how the public was going to judge this case, right? And I find that brilliant and fascinating that I think, the boat crash, honestly, and the way that that the Murdaugh family handled it and treated the Beach family, the Cook family, because it was Anthony and Connor Cook, who are cousins, their girlfriends, everybody on that boat, aside from Paul, they were looking out for their kid and their kid only. And while I understand being protective of your child, that's a parent's job, that's what we're supposed to do. When your child does something like this and it's your boat and your other son's ID that bought the beer, it's, you got to do the right thing, period. And I feel like that is really when the public, the town, started, I think it was just really the straw that broke the camel's back in that town. They'd been getting, they'd been treated differently and special for, 11 billion years with, their family, pretty much running the town and whatnot and having deep roots and stuff like that. And I get it, but the town people hadn't had enough. And I think that I feel like, this goes back to something that I said either on my channel or on Kate's about Alec thinking that Paul was likely going to face jail time, because if a mock trial in a for a civil case went the way that it went, then it would likely a criminal trial would have gone the same way. I think that it is a very, very real and distinct possibility that had Paul not been murdered, he would have been convicted and he would have been serving prison time. I really do. Oh, and yes, Alec is mean mugging this gentleman the whole time. All right, here we go.
Had you come into possession of some that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick.
Well, hey,
We'll show you what's
Chef
marked as
Cap,
Exhibit
long time
401,
no
State's
see.
Exhibit
How's it
401,
going?
and see if you recognize that document.
Oh,
I did. I do.
Right, and what is that
Chef
document?
came in with
It's
the
a
hands,
screenshot
not
of
the
text
eyes.
messages
I'm
between myself
shocked.
and Tabor Vox.
That's a
Tabor
new one.
is assisting me in the boat
comes
crash
in here
case.
with the papers.
All right. Could you turn the screen to me real quick, please? All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking 5 and not walking away from someone who's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just really quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel.
Okay. So I got to pause again for some commentary here, but let me just, the fact that it was going to be Harpootlian and what is his name? Why can't I ever remember it? I know Jim is, oh, did the eyes happen? Oh, dadgummit. Shift. Well, oh, yep, there's the eyes. Anyway, that's fascinating because boy, howdy, did they open up some doors that I know they're regretting. I know our Pootland has got the regerts. And let me just say this too. On the Twitters, you know what they call Harpootland, in case y'all don't follow the Twitters? They call him the Poot. Cracks me up every time. Now, I gave him a name at the beginning of this, and I called him Bilbo Baggins, like not young Bilbo Baggins from The Hobbit, but Bilbo Baggins from The Lord of the Rings. Because he kept putting his hand in his pocket, you know, like Bilbo would when he was trying to fiddle with the precious. Yeah, it drove me nuts. Hello, welcome everyone. Welcome, welcome, welcome. Oh, wait. Since we got some new people coming in, let me play my thing.
And Kai, when you're on Jen Lou's channel, what do you do with the like button?
Smash, smash, smash. Yeah.
Alec said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel. And about a week after I'd filed that motion to compel, Danny Henderson,
so I want to slow it down just a little
Alec's
bit.
personal lawyer, came to my partner, said he couldn't believe that we were going after Alec personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, you know, by November, this is, I think, November of 2020, the Beach family, they want accountability.
Yeah, I think
they want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't have been.
All right. And why did you not believe that that was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec
man. He's a whole
and his family forever. And so their perspective is that there's generational wealth as well.
Mm-hmm.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective. Okay. I can explain that if you want.
Yes, please explain that.
So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time, Alec thought there was a fix on, that he was just a placeholder, a venue defendant. Right. And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because there was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alec, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take? You know, the analogy I use with my clients is it's kind of like that show Deal or No Deal. You may have the $1 million suitcase or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alec was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open.
Well, it would have been hard for him to do that given the fact that he didn't own Moselle. That would have been in Maggie's name. But I just want to talk about this video real quick. So, yes. Okay, so there's two videos, right? One is a Snapchat video. The Snapchat video is Paul and Alec, and they're riding around in the truck and they're looking at the trees. That's the Snapchat video. The other video is a video that Paul took with his phone, and it wasn't sent through chat. It wasn't sent anywhere. It was just saved on his phone because he had been talking to Rogan, and Rogan tried to FaceTime him so he could show him what was going on with Chase's tail. But it was spotty reception and the Wi-Fi wasn't working, yada, 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 right? So Paul says, all right, I'm just going to take a video and I'm going to text it to you. So it was just a regular, video you take with your phone. And then the Snapchat video is them, is Paul and Alec riding around in the truck. So yes, and that's another thing. There were liens. I mean, this guy was, upside down in every way possible. Bye, Shift. Take it easy. Thanks for coming. Peace out, Girl Scout.
His books to see he was broke and then work out a payment plan on the balance.
So when you say, okay, you say he's broke, I don't believe that. Show me the books to prove that. What was your response from Alec's defense?
Well, it was sort of stonewalling
thank you, Mama
to begin
Bear.
with. I mean, ultimately, I got a formal
Baby Bear.
response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick.
And the attorney who was working as Alec Murdaugh's representation.
Show you what's been marked as States 402. See if you recognize this
I don't
document.
want to interrupt the state attorney general.
Yeah.
That's rude. The attorney who is representing Alec Murdaugh in the boat case is the same attorney who, remember when we watched the interview with the police in the police car, the guy in the back seat, Danny, I can't think of his last name right now. By the way, I do now know, and I've written it down forever on my erase board, my whiteboard, so I can remember it. Alec's attorneys are Jim Gibson and Dick Harpootlian. Anyway, that's the same attorney who was representing Alec in the boat case, the guy in the back seat of the car.
So this is,
and the reason why that detail is important is because after this gentleman testifies, there's going to be another attorney that testifies that talks about a conversation that was had out at the cabin, or the hunting lodge, or whatever the heck it is they call it, at the farm, whatever, And like, they're all intertwined, all of these people. So it's interesting. And that's why it makes a difference. Hey, CB Cal, good to see you, babe.
My motion to compel, which attaches Alec's
Danny
responses
Henderson,
to the
thank you. Let me write that down
interrogatories
too.
and request for production.
Lord
And when
Jesus,
was
I
this
can't
filed?
keep all these people straight. I need a flow chart.
October 16th, 2020.
All right.
YouTube is so rude, Mama Bear. This is why like I
All
have
right,
to
I'm gonna
like
put Exhibit B
remind
to this
everybody to
motion,
give
your
me the
motion to
thumbs
compel up
up
on the
because that's
screen
what helps
and zoom it in a little
get the
bit.
notifications out.
And in part, was this the objection to one of your
Thank you,
supplemental
Seth.
interrogatories about what
Have a
you're talking
good
about
night.
opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number one, please.
Well, in as broad terms as
Well, let's just read it real quick if we could, please.
all
Can you
right,
read that?
list all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRA maintained by
5778,
you,
good to see
IRAs
you.
maintained by you individually and or jointly
Thank you,
with
ma'am.
any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
Oh,
And
bless
ultimately,
your
what
heart.
was the
I knew her,
Alex
CB
defense's
Cal.
response to that, generally? You don't have to read
Is
that.
he or
but
she
tell me.
okay?
It was overly broad, unduly burdensome, and irrelevant.
And so ultimately, you filed a motion to compel, is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others, is that correct?
Correct.
Yeah, they weren't trying to show the books.
All right.
They were gonna, you know what I think they were gonna try to do with this attorney, if you want to know my opinion, I think they were gonna do like, remember Aaron Brockovich and what PG&E did? They were gonna bury him in paperwork. I think that's what Alec Murdaugh and his legal team were intending to do to this attorney.
To your knowledge,
Exactly.
when information was being
Jessica.
gathered
Exactly.
by the defendant in this particular case, let me ask you this, who were his attorneys in the boat case, Alex attorneys?
So his personal attorney, as I've said, was Danny Henderson, who is also a partner or shareholder with PMPD. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon. Ultimately, I think Amy left in February of 21, and by then I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case. Is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at them and see what might be available.
Good. I'm
That's
so
right.
glad that he's okay. Good. Poor baby. Poor you.
As this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
Wow.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well, the way to,
Thank you,
again,
Seth.
like in my example of the deal or no deal, I mean, what I'm trying to do is put
Absolutely,
pressure.
CP,
He doesn't
no.
want me to have access to his accounts.
No, he
At the
doesn't.
time, I think it's because I'll see how much money he actually is making and how much he has. And so, that's what I'm trying to do is put pressure on him
Oh, it was so good.
to
The
force him
cross-exam was
into
so
a
good.
settlement. You don't want it disclosed. Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alec's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
That's right.
Explain that to the court. When
Thank
you say
Seth,
that
too.
you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
Absolutely. And this guy was like, you are not going. Let me say
If
why I like this guy
ultimately,
so much. Hang
and
on.
we'll talk more about this in a minute.
Honestly, with Mr. Tinsley, I think it was a combination of a couple of things with him and Alec. It's the fact that, first of all, his first primary focus was to advocate on behalf of his clients, right? Which were the beaches. All right. But his secondary thing, which I sort of feel like this, was sort of like, how dare you? Just Alec just was being shisty about the whole thing and lying, which, I mean, I suppose in a way he was not completely lying, like he was sort of broke, except for the fact that, Palmetto Bank, when he had the overdraft of $350,000 and the bank deposited $400,000 for him, like the prosecutor said, possibly quite the most generous overdraft policy ever. Yeah, that was ridiculous. But anyway, at the end of the day, I feel like I would feel the same way with him. I would be like, who do you think you are? I know you're making money. You're making money. Now, why don't you want me to know you're making money? You know what I'm saying? Like, I would have thought he was trying to hide money. I can't imagine that Tinsley had the first iota of a clue that this is what was really going on. That Alec was ripping off his own client. Oh boy, Alec, that's not a very good face there, sir. That is an unfortunate time for me to pause. Not really working your angles there, sir.
If ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once you see
Subpoenas.
Of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank.
Absolutely, Jessica.
So
Absolutely.
I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there and some which would not have even been in his name.
Exactly. And instead of just, well, at this point, he couldn't just.
After
take
the
it on
motion
the
to
chin
compel
and
is
do the
filed,
right
I'm going to show
thing.
you
Way
what's
too-
been
he
marked
was
as
in
stakes
way
4
too-
or 3 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot
Absolutely.
of text messages between Tabor Vox and myself.
All right, put this up on the screen. All right, if you would, got this
No,
up
you're
on the
fine,
screen.
Stevie
So
Keller.
can you
You're
tell me
not
what's going
distracting,
on?
chat.
And
You're
again, this is
good.
in April of 2021, is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah. So in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to, I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that.
Okay. So this is how I understand hearsay to be legally. Okay. It is hearsay if it is going to the truth of the matter. And the truth of the matter in this scenario is the financial shenanigans, crimes that Alec Murdaugh was getting up to, and how that relates to his motive for murdering Maggie and Paul. So he's not going into what the at this point anyway, what the texts actually say. He's giving an overview of a conversation between him and another attorney. And also, this is an in-camera hearing, and the rules are just a tiny bit different. The judge is going to listen to this testimony to determine whether or not the probative value of the questions outweighs the potential prejudicial nature of the testimony. So likely, because the judge did rule that he's going to allow in the financial crimes, he's limiting the testimony. So likely this conversation would not be, and he wouldn't ask this question in front of the jury. This is really for the judge. So it's a little bit different, but I get what you're saying. Hey, Poppy, good to see you. All right, here we go.
Greg Parker's convenience store was also a case, but Greg Parker had done a number of things. And so before I leave, the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort.
And as long as he doesn't,
by the time I get back,
hold on.
I think I'm staying in Hampton. And so
as long as he doesn't refer to anything in those texts directly, like he doesn't read them or say that the other party said X, Y, and Z, it's okay. He can talk about the conversation generally and as a whole. He just can't say anything specific. All right, here we go.
This conversation is, for the first time I've said that I'm going to leave the case in Hampton. But if I think that Alec has fixed a jury, that he's done anything to affect the outcome of the trial,
Oh, wow.
that I'm going to sue Paul and Maggie the next day in Beaufort.
Holy guacamole.
Was that communicated to the defense?
Absolutely.
Did y'all hear
In the
that
course of
part?
your investigation of this case, had you taken depositions of some of the officers?
Absolutely. Of the trial, that I'm going to sue. But if I think that Alec has fixed a jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
Was that communicated to the defense?
Absolutely.
In the course of your investigation of this case,
There
had
you
you
go.
taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me. But
I'm asking you today.
But yes,
Isn't that interesting?
Ultimately, and while you were in Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
correct.
Okay, this is another important point. Okay. How this guy isn't scared for his life after knowing what Alec Murdaugh is capable of, I'll never know, but good for him. So while he is investigating the boat crash, he learns other evidence that could potentially impact the criminal investigation of the boat crash and turns it over. You, sir, are the real MVP. You and Jeannie. Y'all said enough is enough. Look at Alex's face.
And
Ooh-wee.
specifically the handling of the criminal investigation by law enforcement.
The investigation into the investigation.
Correct.
Oh boy. The investigation into the investigation. Yikes on the bikes. You're sure right about that, Crystal? Come on, Mr. Prosecutor.
So you're for this hearing, and see if you recognize those, please. Generally.
I do.
All right. And tell me what's going on here, please.
There were a number of
looks like he has
motions
nervous
pending
guts, like
in the
he's
boat
not
crash
sure.
case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend.
Good. You know what? They are, Jessica.
And so
Good for them.
Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple weeks to sort of get my wits about what's going on, and the motions are scheduled to be heard.
And that's May 11th, 2021.
It's either the 10th or my recollection is the 10th. I know the emails say something different,
is the
but
10th, Mr. Tinsley,
and
just so you know.
in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing,
that's what he looks like
his
from
chemotherapy
my
was going to run
vantage
long
point.
and he wouldn't be done. And he had asked the judge to continue
Oh, yes,
the
Jessica,
motions, including the
absolutely.
motion to compel.
All right. And looking at, again, we're now looking at.
Absolutely. He no longer does the Dahmer rocking, as I call it. Jeffrey Dahmer was a rocker as well. But he doesn't rock when the jury is not in. He looks like right now he might have he might have trusted a fart and now has regrets. That's really what his face looks like right now. I'm serious. Which I know I'm not supposed to be making jokes or whatever, but if you know me at all, this is exactly what I do is talk about it, but I make jokes too, because you got to lighten the mood.
States 405. What was the judge's initial response to Mr. Tiller's
You're never late. You're
request
right
to have
on
that hearing
time.
continued based on his chemotherapy?
We don't be taking
We were going forward.
attendance
as
over here at
scheduled,
the
and
board.
It says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at states 406.
Yes,
what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions.
I have to make
Parker's had some
jokes.
motions,
I
but
can't help it. I can't
that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right.
I mean, just look at him. I really need to get that clip from the Stephen McDaniel.
Initially, Judge Hall did not want to continue the May 20.
I really need to get that clip from Stephen McDaniel's interrogation where I call him Officer WD-40 because he's rocking in that chair and it's just so squeaky. But I'm sure he has the actual government name. I just don't know what it is. But anyway, where Officer WD-40 tells Stephen, "You're fucked either way." It's my favorite thing. I need to clip that and upload it to StreamYard. So when we have these moments, because I feel like we're about to have several of these moments in this trial, we can all remind Alec Murdaugh, "You're fucked either way."
2021 hearing saying that there was another lawyer for Alec's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Is that correct?
After a status conference.
After the status conference, it was rescheduled.
Oh my God.
It was rescheduled to June 10th.
June 10th? All right, I'm going to show you what's been marked as stage 407 and stage 408.
Oh, Crystal, that's a good one.
Just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right, so the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alec Hall, identification of all accounts. Is that correct?
Whenever they swing the camera around.
It is correct that motion was going to be heard.
I'll show you.
And
I'll freeze it. Hold on. Let me get over to it so I can show you. Right there.
ultimately, when the murders
He's standing right in front of him, but can you see my cursor? The poot is right there. That's Dick.
happened, I'm going to show you what's been marked as Exhibit 408. What happened to that particular hearing that was scheduled that way?
It was continued.
All right. And is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
Answer him. There you go. Okay. All right. The poot is usually on his Mac.
After the murders happened.
I think personally he's playing word womp. But I can't be sure.
Let me ask you this.
Yes.
You know Alec and have worked with him for a number of cases. Is that correct?
I had not worked with Alec in a number of cases, but I've known him for a long time.
Okay. But you were generally familiar with his work. Is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
He was particularly good
We're
at.
going to stop you right here. I don't want to interrupt you, but I got to pause for commentary. Oh, Poppy, yes. The poot was livid. And I hope they didn't ride share, or I hope they don't have to walk out together, because Lord, I would not, or be in the office together. Listen, there's fixing to be a donkey barbecue. Mr. Gibson, you finna be at a donkey barbecue. The poot is pissed. You've done too much today, sir. Shit, you've done too much this whole trial. You're the reason that they're going to allow this stuff in, because you done opened the door, sir. All right,
Reading
this part's
people,
important.
making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. You have a case with Alec. He hasn't done anything. It's Monday morning of the roster. Maybe you expect it to be continued. And he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the
He does, Jimmy.
emotional and sympathetic aspects of plaintiff's
Gibson
work
is
and tort
problematic
work that
for
can be
Dick.
so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at reading people and knowing what made people tick.
You've testified that you had made it very clear to the defense throughout this time period that you were seeking a substantial personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that. Show me the books, correct?
Correct.
Pretty
That
much.
What was on the table for June 10th, 2021, correct?
Among other things, but
Among
yes.
other things. But that's on the table, correct?
Correct.
Yeah, poot.
After the murders happened,
just meandering around.
did that have any effect on your assessment of
No.
the case against Alec, and particularly as it relates to the sympathies and the emotion of the case, which can be so important to recovery?
This is the part. This is the most important part.
I mean, yeah, yes. It did.
Explain that to the court then.
Well, initially, probably say the first week, there was the shock and horror of what had happened. And nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
Would be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, you know, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case. So I would have ended the case against Alec.
You would have ended the case against Alec with just...
You know, I probably, I mean, certainly there was $500,000 in insurance that was offered. I may have tried to see if he could cobble together the $1 million, but whatever the last offer would have been from Alec's side, that would have been the offer that we took.
All right. Now, did y'all hear that? I know we got stuck on Dick and the poot and the beef. Okay, so Heather, Jim Gibson is co-counsel. So he's on the other side of Alec. But did y'all hear that? What he just said? He would have stopped the lawsuit against Alec on behalf of the Beaches and taken whatever the last offer was and settled it, because Alec would appear sympathetic to the jury. He's no longer Attila the Hun. Now in this scenario, is it Griffin or Gibson? Let me look it up again. I swear Is it Griffin? It might be Griffin. Anyway, in this scenario, yeah, it's Griffin. I don't know why I wrote Gibson. I guess I was thinking of a guitar. Who knows? Anywho, so see, it doesn't do me no damn good to write anything down if I'm not even going to write it down right. When they started this lawsuit, let me write this down real quick before I forget and say his name wrong 80 different times. All right. When they started this lawsuit, Alec was Attila the Hun in the scenario, right? And after the murders, instead of being Attila the Hun, he became the sweet little old grandmother. And nobody knew that better than Alec. That is what Mr. Tinsley said was Alec's specialty. He was incredibly good at reading people, making people feel as if they were the most important person in the room. So when people ask, probably Heather, that's probably where I got it. So when people ask, how would Alec benefit from Paul and Maggie's death? Well, right there. They would have taken the whatever the last settlement was, which is about $500,000. They would have pursued the other defendants in the case and walked away from Alec. And that is how he would have benefited. Point blank, period. That's how it works. It's not benefited with actual money in his hands, the way that most people think of a financial motivation. Hey, Jane Doe, good to see you, babe. The way most people perceive a financial motivation for a crime, where they actually receive money. This is not what that it's not the same for Alec Murdaugh. It was, I think, yes, I've learned a lot. I believe firmly that Alec, if it were if it were some other person, this would be a stretch. But the fact of the matter is, Alec Murdaugh was a practicing personal injury attorney. He knows the system. He knows how it works. He knows how to play to a jury. He knows how to you've got to make your client come across as sympathetic. And so at the beginning of the boat case, Mr. Tinsley compared it to Attila the Hun and a little old grandmother. Okay. And at the beginning of the case, with the mock trial, etc., Alec Murdaugh was Attila the Hun. But after the murders, he then became the little grandmother, the little old grandmother. And nobody is going to take money from the little old grandmother. And at that point, he did not really, nobody knew, this gentleman did not know how, I feel like Morpheus, how deep the rabbit hole goes. Like, he didn't know all the things that were that had been occurring, right? So he said that he would have settled the lawsuit against Alec Murdaugh because of the murders. And that's what the motive was. And Alec would know that, being a personal injury attorney. That is why he did it. And when, after the murders occurred, and Jeannie over here was not stopping the full court press about this money, that's when he then said, oh, let me be attacked again. Although I personally think that he intended to not survive that last situation with cousin Eddie, and I think personally he was going to have cousin Eddie left holding the bag and possibly get blamed for Paul, Maggie, and Alec. Buster inherits whatever he's going to inherit, and he carries on the Murdaugh name as a legacy. He's the oldest son, et cetera, et cetera. So, yes. Yes, CB Kell, Kate and I talked about that. And I'm sure I have a feeling that because the judge allowed the financials in, I am very curious to see if this situation with Maggie's will comes up, but I don't know. But yeah, yes. I mean, look, him and Jeannie found it. All right. So I do want us to watch The Cross because it's so good. I'm just going to speed up a little bit because we've heard the most, and what I feel personally is the most important part. And I think that if he explains that analogy or metaphor, I can't ever remember how to distinguish the two of them. Regardless, if he tells that same story on the stand in front of the jury, all of this stuff is going to get tied up very, very neatly. All the dots will connect. That is a story that the jury will remember. Do you know what I mean? They'll understand that, because bless their hearts, are not allowed to take notes, which I don't know how they're doing it. I literally can't take notes. Yes,
You mentioned
Susanna
before
J.
that you had advised the defense of some of the
exactly
mock jury
right.
presentations that you had done and some of the results from that and how they were very favorable to your case. Is that correct?
The defense and some of Alec Partners, yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to your assessment then in the wake of these murders. Is that correct?
Correct.
Oh, well, thank you, Poppy. Thank you very much. Welcome to the board, all of you guys. Welcome.
Did you receive any call or any communication from the Satterfields about any recovery of the Gloria Satterfield death?
At some point, my recollection is it's early September of 21. Eric Harriet came to my office about that. There are a number of articles in the paper that are talking about this previous wrongful death.
Now, I will say this, and this is a really, really good point. I've learned a lot. They're going to be allowed to take exhibits and stuff back to the jury room, so that will be helpful. I think they even can have testimony read back to them. But I really, really think that Mr. Tinsley and Jeannie their testimony is going to be testimony that sticks with the jury, particularly Mr. Tinsley's analogy of Attila the Hun versus the little old grandmother. I'm a Grammy. So yes. Oh, thank you, Cement. Cement, I'm going to give you a wrench. If you don't want it, you can just tell me. I'm going to give you a wrench. You're doing fantastic. Welcoming people, being a cool dude. I appreciate it. So yeah, like I think I think that he ties the motive in very, very nicely, and it'll be something that sticks with the jury. Well, you've got it now, Cement Shoes. All right, let's keep listening. Maybe I should skip a little bit. Let's skip a little bit. Let's get to the cross exam, because that's what's important. We heard the most important points of his direct testimony. Let's hear the cross. All right. You do look rather dapper in blue cement shoes.
Good morning, Mr. Tinsley.
How are you?
Well, that's a good, you know what,
You
Jenny?
testified
That's
at
a
length
good
to the state
point.
grand jury, basically, this similar testimony you've given here today. Is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that pursuing Alex Murdaugh,
That's a good point.
you believe
We'll see
was
how they
underinsured
do.
for this incident, and you're going to go after his personal assets.
I love this
And
part
that
too. I'll
was
be
what
right back,
put
but
some
I'll be in
financial pressure
chat,
on
so
you.
y'all
Is that
behave. Cement, you're in charge.
Probably not exactly. I mean, I don't mean to quibble with
It
you over
really
the
is.
word
I
you
adore
used, but
cement shoes.
I don't think it was financial
I
pressure
adore all of you
because
guys, really. I have
I was
great
holding him
chat.
personally
I really
accountable.
do.
I was insistent that he pay. I didn't
Oh,
see
Jenny
how a
done
payment
won the
plan
internet
on
though
a
today.
settlement would put any
Jenny's the good
pressure on
noodle.
Alec. It was,
Sorry, I don't want to interrupt Mr. Tinsley, but yes, that you're the good noodle for today's stream, Jenny, because that one so apropos. Well played. Well played. All right. I'll
sort
be
of a
right
deal
back.
that he could turn down from where I sat.
But you were asking for money from
Oh,
him.
sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99. But if we had to try it, yes, we were going to try it.
And if you were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money. No money had been offered.
So your expectation then was we're going to trial.
If you offer me no money in a case that I'm pursuing against you, then the response is we are going to trial.
And you were pretty far from trial on June 7th, 2021, were you not?
No.
You believe you were close to taking it to trial?
There was an urgency because John Tiller knew that he had about a year to live. And we were going to try that case. My expectation was early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time.
You felt like you were only 2 or 3 months away from trial?
Sure.
Even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
On that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex Aiden.
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment.
Right.
There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that claim to the court. That wasn't before the court, was it? That was just a conversation with John Tiller.
That's the conversation that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
But he had objected to the financial discovery you asked for.
Well, there was an objection posed, correct?
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
And the hearing that motion to compel the financial detail, the testimonies, that's just one of many motions that needed to be heard. Is that correct?
Correct.
There are many motions that had piled up and needed to be heard.
There were several.
There were several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. there was, Parker's had one or two motions. Some of the motions got resolved, one of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
And you've had a lot of motions practice in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video from mediation, for example, correct?
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking to amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video. That's a separate matter, and ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
And you didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's put that up.
I wanted it, but I didn't need it.
Show you what's been marked as Defendant's Exhibit 82. You recognize that?
You know what Alec Murdaugh is, his face is saying to me right now? You know when Scrappy Doo be trying to get at the bad guy, you know, the let me at him. That is the look that Alec is giving right now. That is, he is a whole mood. Like, this goes beyond, you get a Lunchable and you don't have an even number of crackers, meat and cheese. The ratio is askew because somebody ain't did their job, and so you're down a cracker and all you got is, the meat and the cheese, and you're just fed up with the bullshit. That's Alec's face right now. Hi, Sam. Good to see you, babe. Yeah, look at him. Let me at him. Let me at him. Yeah, that's his current mood right now. He's livid. And look at him looking at Jim Griffin right now. Bruh, I want to fire your ass so bad, but I'm not even paying you right now because y'all know I'm broke.
It appears to be my motion to compel against Greg Parker's company.
We ain't talking about Parker's right now. See, look, I get why the defense is doing this out here, just conflating the issue. But hey, Steve Star.
And this is the document on the screen that I've handed to you. So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for
Is there a
production
question?
19,
Hey, nonstop,
request
Mom.
for production 20,
Is
request
there
for
a
production
question in here
22,
somewhere?
request
Counselor?
interrogatory number 5, interrogatory number 8, interrogatory number 9,
Look at
interrogatory number
Mr.
10,
Tinsley. I ain't a
interrogatory number
criminal,
12,
motherfucker. I
interrogatory number
can
13,
read.
interrogatory number 15, interrogatory number 18.
Well, all right, nonstop,
It
Mom.
seems
Make
like
sure
it's
you
quite a
get
bit of
that
discovery
thumbs
you're
up and love
demanding
before you dip,
from
ma'am.
Parker's in this motion.
Which I would have had the answer to on June 10th.
So you didn't-
Either I was getting it or I wasn't getting it, but
He was
my
prepared
case
either
wasn't
way.
dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alec, but
Yeah, but you
the
haven't
trial
watched
wasn't
it with
dependent on
my
these things.
jokes, nonstop, Mom.
And
Come on.
turning to the motion to compel Alex, first, do you believe that the Judge Hall's
That's a new
initial request in May to go forward with pending motion hearings
Southern State I haven't heard in a minute, before ever.
telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. There's nobody in the courtroom, maybe even including me, that wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked
probably tired of your
for
freaking stall tactics.
a continuance,
well, not y'all, but
you don't believe that was any kind of stalling tactic?
No.
Yeah,
That-
broke
that
as
was a
a joke
legitimate
is when I
health-based
know so
concern.
broke I
And if
can't
you
even
read my
pay
emails, you would
attention.
see that I immediately agreed to it. John Tiller was my friend.
Oh, damn.
With regards to what you're asking for from Alex, let's maybe pull that up.
Are you going to pull this up today?
Mark this as an exhibit, but this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as.
Oh, look at Alec right now.
Reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental request for production. Is that correct?
It is.
And if we turn to
And 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10. Because,
Yeah.
9 and 10 asked Alec about.
Sir, no one's asked you about it.
Okay.
You haven't asked anything yet.
And we'll get to it, but first let's turn
We've
to
been waiting for you to turn pages all
answers to
day.
the first supplemental interrogatories. This is the
That's
first page
right.
of Exhibit B. So we can see what it is that is being asked for. Keep
There's no D in mine, I'm sorry.
B.
Oh,
Exhibit
B.
B. It's the first page of what's Exhibit B in here. It's right there, that's it. It's the first page after the motion, so it'd be page 9 of the PDF.
They're not
So
numbered, but
Mr. Waters asked you about this list of all checking, savings accounts, retirement accounts. And then you don't have to highlight or expand this stuff. All stock, and then number 2, all stock certificates, and we go to the next page. All property interest of property of every kind whatsoever, from February 24, 2019 forward. All life insurance policies, 4 or 5, all personal financial statements submitted to any bank, et cetera, profit sharing plans, pension plans, et cetera. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I never had been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alec would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and in an alcohol-related incident.
I agree. I've learned a lot.
Before there's even
I'm
motions
pretty
for summary
sure that's a
judgment,
wig.
before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to him.
He agreed to give it to you.
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
Oh, damn.
He granted this motion?
I think so. You want to see the order?
Yeah.
Uh-oh.
It's
It
the
is
record,
side-
October 7th, 2021.
Oh, sweet. Uh-oh.
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because of circumstances beyond his control, unable to gather, provide necessary information, answer requests and interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If necessary. The
Yes.
court will schedule a hearing
That's
if
right.
necessary.
Which
If
means,
Mr. Tiller, the attorney on the case, can from his own client get the information. This is no way says that the court granted this motion, does it, sir?
only to you, I think. I mean, it's clear that John said that Alec was unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
I mean, this is an order that says the court will schedule a hearing on this motion to compel if necessary.
Yeah.
It's
My
not
only-
granting the motion to compel, sir, is it?
Oh, I think so. I think if he was just going to deny it as you suggest, then it would have just said denied. Or it's
If it was
it's
granted, would
premature.
we say granted?
Well, I think that's what it says. As a practical matter, when parties have discovery motions, oftentimes, like Alec has in his own statement said he was working on getting the answers. The reason is you give the answers because you don't want to face what could happen in the argument with the judge. So my point is that if the judge were going to say it's premature, you're not going to get it, it's denied, any of the things you suggested in your motion, he would have said that. That's not what he did.
Yes,
That's not what
Gregory.
happened.
He's definitely turning up the red hue. If this were Photoshop, yes, he would be hitting the red hue and hitting plus, 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 plus. This is, oh, for Pete's sake.
October 6, 2021.
Is there a question there, Counselor? Or are you just talking to yourself? What's
You asked for
happening?
financial information in the motion that was pending against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
You asked for alcohol sales, correct?
What I explained to Judge Hall is that they say he's broke. And before
No, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things, the percent of alcohol sales that made up
Even
his
Alex
net
knows
profit.
this line of questioning from
And this was like a
witness
dram shop action. against
relative
Parker's,
to
correct?
what the
They sold the alcohol.
hearing is
Like a dram
intended
shop,
to
right.
do
Yes.
is absolute poppycock.
And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th day, just along with all these other motions that had piled up in a case that apparently wasn't moving very
Well,
quickly.
I understand you don't want to acknowledge
from
what I've
Parker's-
handed you, but
Sir, I asked you what the ruling was on the motion.
And their
Well,
to compel from
wife.
Parker's.
it was very limited. And as it related to the percent of sales of alcohol that made up his profit,
No, I don't think.
it was
he does.
premature.
Parker,
The judge
I really
ruled,
don't.
unlike he did in that order I handed you, that it was premature at the time.
Why was it premature?
Well, the difference between Parker's and Alec is that Alec had, and his lawyers had 25 videos of alcohol. They had the punitive damages evidence. You didn't see that with Parker's. It was just a straight up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the
You
argument.
presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front
So
of the
you're saying
judge.
the court was granting your motion, though obviously it was saying there might be a hearing on the motion.
Thank you, Piper.
And maybe at
I'm
that
telling
hearing
you,
you
I
would present
couldn't
some
do it
evidence
without
in
the chat
support.
Because I'd be forgetting these people's names.
But
I don't think that's
left
what it
in
says.
line.
I mean,
Hell, I even wrote one down wrong.
you asked for financial information from Parker's it was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Alec.
Because the law is how much money you have is a factor for punitive damages, correct?
Oh, sweet Jesus. This is really going to make me mad. I listen. Now I understand that it is a defense attorney's job to mount a vigorous defense. Okay. But we're talking about Alec Murdaugh, not Parker's liquor store or convenience store, excuse me. One thing does not have anything to do with the other. Unless if you're going to draw a parallel, Mr. Defense Attorney, it's a poor one to make, because I would argue that there are multiple people listed, including a business entity, in that lawsuit, and none of them have a wife and a child murdered. So there is no parallel. Everybody got served with the same motion to compel, and yet none of these other people listed in your client's boating accident lawsuit thought that the answer to a motion to compel is allegedly shooting your wife and your son. Nobody else's family members died during this, just Alex. So they're not the same thing. You're comparing apples to dog food, and it's ridiculous and preposterous. And now you're getting on my nerves. So let's keep going.
Right.
Well, statement of law happening, and what was happening is that Alec's lawyers knew what the evidence was. They knew what the amendment was going to be and the allegations. And he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that I hear you're suggesting now.
Oh,
and
Jesus.
Again, the gist of this is that there was perhaps going to be this judgment day, I think is a term the state has used, but that was going to be trial, right? That was going to be the verdict. That was going to be judgment day, not this motion hearing where there's a pile of motions that have piled up. And
listen, again, for the 11 billionth time, the judgment day was coming on the 10th because the judge was very likely going to rule in the petitioner's favor and order Alec Murdaugh to open up the books. You know it. I know it. Alec Murdaugh knows it. Everybody in this courtroom knows it. And this is literally the worst flim-flam ass argument ever. And I didn't even go to law school. I only got my good enough diploma. And I've already argued circles around you. Go sit down.
we saw the one that asked for financial information was deemed premature.
Not at all. You know, what was going on is, as I've said a number of times, Danny Henderson was very involved. Danny Henderson was a shareholder. Before I would have gotten the bank account information, before I would have seen the records, Danny Henderson would have seen those records.
Of course.
And I've seen the records. I've seen all the bank statements. Now, it would have been apparent to Danny Henderson, and I believe it would have been apparent to me what Alec had been doing. So that's the judgment day, is the discovery. And there were a lot of threads that were being pulled, and it was subject to unraveling at any moment. And if those records were disclosed, if Danny Henderson reviewed those records, he would have known there's no way Alec's getting these checks. There's no way these checks are going to Forge. There's no way that this money should be transferred.
Boom
And
shakalaka.
even if hypothetically,
Well, that's
had
what
this
the
hearing on
if
the
implies. It's the hypothetical.
and you got a different ruling regarding Alex Murdaugh than you got against Parker's, but for some reason it's not premature to him. Isn't it true all you would have been enabled, all you could have gotten would have been a net worth statement, financial statement?
No.
Not even remotely close.
Isn't that you don't, in your opinion, there's no case law out there saying that's what you get, for that's the measure for punitive damages, net worth. There's no such case in your opinion as an attorney.
Possibly.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion, and then what are we going to do? We're going to try the case, and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, the issue is not that complicated.
It's really not.
Does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it together?
But sir, that's not what you get on a motion to compel, is it? Right, you just said ability to pay so your client can make a decision on whether to accept a settlement offer, but that is not what the motion to compel is about, is it? It's about evidence for trial. That's the legal standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really give 2 cents about whether or not
I don't think
he
you
ultimately.
meant 2 cents, but I appreciate you editing yourself. I'm sure you meant 2 shits, which is exactly how I'm feeling right now. I'm going to Tammy's clips. Now that Aiden Fucci has pled, because I was going to cover both trials, I'm probably going to start streaming in the morning. I'm going to start but I absolutely for sure will stream whenever cousin Eddie hauls his keister up to the stand. I will absolutely be streaming that live.
Had money because I knew he had money. I didn't need those things. The fact that he didn't want me to have them is the reason that I'm pushing it. I just didn't know why he didn't want me to have them at the time. I do now.
So the motion to compel was to put pressure on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
Amen.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see.
Thank you.
So, no.
You wanted pre-trial ability to pay discovery to inform whether or not to accept a compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alec. I think that your assessment of the law is wrong, and I didn't really care whether I got it at the end of the day. I knew he didn't want me to have it. And so that's what I was doing, was putting pressure on him. Would have suited me fine not to have ever gotten anything and to leverage it into a settlement and gone on about my way. Yep. That's not what happened.
Sure ain't.
So the motion was not about obtaining information that may have been relevant at trial.
All right, let me just stop you right there, okay? Maybe you are confused about what we're all here to do and why this gentleman is on the stand testifying. So let me break it down now for the 3rd time. It doesn't matter what the judge would have ruled. Alec didn't want him to have access to his financials in any way, shape, or form. And by the way, if it is, as you are trying to say it was, that this motion to compel would not have afforded Mr. Tinsley his books, then why, sir, was Alec on June 7th calling the HR, Jeannie, who also is the accountant, and inquiring about his 401k? Because he knew that the judge was going to grant that motion to compel. And he was hoping if he showed up to court with the 401k, it would be good enough. You know it, and I know it. Even Alice the damn cat knows it. Stop playing with this man out here. It's insulting to all of us.
It was about getting information to inform whether or not your client would take a settlement offer.
What I told Judge Hall was,
I know, but they're irritated.
My people have lived in Hampton their entire lives. They do not believe he's broke. If he's broke, we need to open the books and let them see it so that they can then form an informed
decision,
opinion about what they should do.
Correct.
It didn't have anything to do with the trial. It had to do with the case and resolving the case.
And then
Exactly.
I think we briefly touched on Satterfield. Just to be clear, they came to you, the first time they came into your office, or any was September 21?
Angry, Mimi, you're good.
It's either late August or early September, but very early September. And since now I'm thinking that since the roadside shooting, whatever that ridiculousness was the 4th, it could have been August.
Okay. But it was well after June 7th.
It was after June 7th.
Oh, there's no way.
Courts and buildings.
I would be so shocked, Tammy, if he took his hand. I really would be.
Going forward on June 10th, this was a Thursday. What outcome did you expect?
Thank you, nonstop.
The same one
Mom.
that
I
we got when
appreciate
it
that.
went
Thank you so much.
The judge hadn't seen.
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome would you have expected?
Well, now I know that Alec was working on Monday to get the information together.
Well,
If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information. But since that didn't happen, if we had argued it, I think I would have had the same outcome.
which is again why Alec was.
Because he didn't.
Let me just make it a little simpler. Would the court have issued an order, right? Some order would have issued on the motion.
I would expect an order.
To break it down. An order would have issued at some point later, and what, if it were granting your motion, what would that order say?
I think it would say the same thing as.
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So what would the order granting the motion say?
Look, again, what it says is that once Mr. Tiller gets the information from Alec, gives it to me, if necessary, if I deem it insufficient, then we'll have another hearing and we'll argue about it. So that's what I expect.
It's a voluntary disclosure, and then if you deem that insufficient, we go have a motion to compel hearing?
That's the way motions to compel go every single day.
So if you deemed it insufficient, if the court actually had to issue an order on your motion, what you would have gotten
We're just at this
you've gotten
point
his,
arguing
the
in
law firm
circles.
books have been open to you?
He's not going to agree with your.
I don't know
what
that
you're
I'm asking
saying,
for the
no
law firm
matter
books.
how
I'm
many
asking for
different ways
Alex.
you try to
Right.
ask.
Would
him.
you have
Move on,
gotten
counselor.
a financial statement?
No.
The court would have ordered every account detail listed to you, all those personal accounts? Just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I told you that a couple
Right,
times.
to subpoena.
Sure.
And
But that's different.
And
than
that would
him
have been
giving me-
resisted, and there would have been further litigation. This process would have taken some time, would it, if it was resisted, right?
I'm not sure what was resisted.
If you got the names of the banks and issued subpoenas, there would be motions to quash the subpoenas.
Well, you're
Right.
speculating the same as you're asking me to speculate. I'm trying to talk to you about what the judge actually did and what was actually in front of the judge. I get you don't want to talk about that, but, and we can speculate any number of things could have happened.
That at some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel. That's what you say it says, right?
What is your point?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not
Isn't
it was
so
relevant,
sorry?
whether or
I
not
always
I
thought
was
that
entitled to it.
interesting.
And you'd have been relevant for Alex, but not for Parker's.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Alec. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller is going to get the information, give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that.
You can't.
The court's-
Oh, God. You already looked through your paper. You didn't have a rebuttal to this rebuttal?
So just, and maybe we can agree on this. The hearing had gone forward June 10th.
Oh, my God.
That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, analysis by you, whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out.
Okay.
There was going to be after that.
The judgment day isn't a literal term, meaning that the case would have been adjudicated, judged on the 10th. What he's saying is, for now, the 11,100 billionth time, is that the motion to compel was likely going to be granted. And when it was granted, Alec would have to open up the books, period. He wasn't going to be able to stop this. Whether he appealed the decision and continued to appeal the decision at some point, the books would have had to be opened, period. Shit.
Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to Danny Henderson. And who would have, like the phone records, like some of the other materials, reviewed it before I got it.
Are you going to move on to
And
the
Alec would have known
question
that.
now? Can we move on to something else? more
In that
pertinent?
analogy, aren't you really saying the fuse was lit when you were going after his assets, and that fuse is going to go down until trial because you're going to go to trial against him, and that's when
Yeah,
the
they
fuse is going
did.
down?
I think the
Right,
fuse
right.
was lit when he started stealing money.
Amen.
Yeah.
So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
Right, but it was lit way before, and it was going to keep burning well after June 10th.
I don't know about well after, but
I guarantee
it
you
wouldn't
he
have
does,
been
Jamie.
Judgment Day on June the 10th, but he would have known it was beginning to unravel.
He would,
Not
exactly,
judgment.
which is the point.
No further questions.
Thank God.
Yes, sir.
Very briefly, Your Honor. And that's really the point, isn't it, though, that had that hearing taken place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
That's the point.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection.
There's only one.
Objection, Your Honor.
Don't leave the witness.
If the hearing takes place
Okay, we
on,
all get it.
because you had been advised
Yes, he didn't want me to discover it.
a bit about having
Let's watch
not,
the defense's face when the ruling comes in.
I
Because we get it. We all get it. This is just going in circles.
Yes.
testified, come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
Involved. I mean, any of us would have thought it was a good idea.
What, do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never
Or did
Buster the boating accident. He was
2 months prior, Beresford's former neighbors called
This issue is before me on the motion of the state
Well, let's just get
to
through
admit
it.
evidence pursuant to Rule 404B of the South Carolina Rules of Evidence, and also under the theory of
Good night,
res
Corky.
geste. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing.
Indeed, Your Honor, it
The
has been
court
extensive.
has reviewed all of the exhibits submitted and I've considered the testimony of each and every witnesses, and I have concluded that the motion should be granted. Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is offered to show motive,
Me too.
identity, the existence of a common scheme or plan, the absence of mistake or accident or intent. And before admitting this evidence, the court must first determine if it's relevant. Our rules define relevance as evidence having any tendency
Autocorrect gets me
to
all
make
the
the
days.
existence of any fact
Some of the best
that
jokes.
is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced. And this requires the court to analyze whether a logical nexus exists. Evidence is logically relevant when it reasonably tends to prove a material fact and issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to must be proven by clear and convincing evidence. And the court is to conduct and required to conduct an analysis.
Is Griffin eating a pen? What's he doing? What's he doing?
Which weighs the probative value versus the prejudicial effect. According to the state, the nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and the one who discovered the bodies, all in a relatively short period of time.
Correct.
The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh. The state argues that the logical nexus between the murders and other crimes is that the looming exposure of financial crimes provided motive for the murders and is evidence of malice, an essential element of the crime of murder. On June 7th, the defendant was confronted about $792,000 missing from the law firm. Beyond that sum, the state contends that millions of dollars were misappropriated by the defendant, and this misappropriation would imminently be exposed. We've heard from the bookkeeper for the law firm, Gene Seckinger, who testified to confronting the defendant on the day of the murders about the missing $792,000 from a case that he worked on with attorney Chris Wilson. She had previously questioned Mr. Murdaugh concerning the improper disbursement of fees in the case of the estate versus Hirschberger, wherein it's alleged that Mr. Murdaugh sought to put the fees in the name of his wife Maggie to hide them from discovery in the boat case. She testified that the firm conducted a forensic audit, which then documented millions of dollars of misappropriated funds by the defendants, funds that the law firm had to replace. The defendant and his son, Paul, have been sued following the fatal boat crash, and the defendant had been served a motion to compel production of his financial information. On the day of the murders, according to the testimony, the defendant was preparing for the motion to compel, which was set to convene in 3 days. We've heard testimony from Jan Milanowski, the president and CEO of Palmetto State Bank, who provided testimony and documentation to millions of dollars owed by the defendant to Palmetto State Bank, all while the defendant was frequently carrying a substantial negative account balances. Michael Gunn, a consultant with Forge Consulting, testified that the defendant created a fake bank account using
Good night, Jessica.
the firm name of Forge. And according to the testimony of Ms. Seckinger, this fake account was used as main depository for a substantial, if not most of the misappropriated funds. We heard testimony from Attorney Chris Wilson about confronting the defendant
too much
about the missing $792 and the personal,
I think you mean 792,000.
sum to him owed of $192,000 was later discovered.
There you go.
And that testimony or that confrontation took place on June 7th. Mr. Murdaugh later confessed to having stolen those funds along with committing a multitude of other crimes, and also claimed to be suffering from drug addiction. We heard from Michael Satterfield, who Mr. Murdaugh, according to him, represented in a lawsuit against himself involving the death of Gloria Satterfield.
Are they going to zoom in more on the poop's face or what? Because he's not really doing a lot.
Of Mr. Murdaugh. He testified that he'd heard of through the reports that money had been recovered in the case, and when he discussed it with Mr. Murdaugh, Mr.
Me too,
Murdaugh
angry
told him
me. It drives me nuts.
no money had been recovered and would take a year or so. It was later revealed that money had been recovered and that a confession of judgment was later issued in the sum of $4,304,000. Also received testimony from
mine too.
Mr. Carson Burney from the State Attorney General's office.
Oh, it's coming?
Traced
Okay,
funds
Crystal,
in and
all
out
right.
of the bank account.
All right.
I find that the jury is entitled to consider whether the apparent desperation
Okay.
of Mr. Murdaugh because of his dire financial situation, the threat of being exposed for committing the crimes which he was later charged with.
Tell me when.
Resulted in the commission of the alleged crimes. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it. And in this
Yes,
case,
thank
since
you,
the
Tammy. I
identity
would
of the
appreciate that. I'm the
perpetrator
worst at
is a
this.
critical element that must be proven beyond the
Because I
reasonable
get
doubt.
wrapped up in the testimony and stuff and paying
Evidence of
attention, and
motive may
I
be
forget to
used
mark down what time it
in an
is.
attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground or than the specific charge. Thus, it is non-propensatory evidence and is supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence,
I think
which may
Harpootlian
be
just fired
prejudicial, but it's
Griffin.
more
I'm not sure what happened.
probative
That was a that
than
was a note
prejudicial.
pass.
As to res geste, the state alleges that Mr. Murdaugh was under immense pressure after being confronted about the missing fees, the upcoming hearing on the motion to compel his financial information, his dire financial straits, and looming exposure of this criminal activity. And the state contends that
Okay. I'll find out for you, Jenny.
that situation led to the murder of Maggie and Paul Murdaugh. Our courts have held that where evidence of other crimes is an integral part of the crime
did, but we're waiting
for
for
which
something.
a defendant is charged, or it is needed to aid the jury in understanding the context with which the crime occurred,
I'm gonna speed him up a little.
then that evidence is admissible under the theory of res geste or res gesti, as some might pronounce it. I find that the activities and conduct as of the defendant on June 7th, 2021, as testified to, is admissible under res geste, and that this evidence furnishes a part of the context of the alleged crime. It's necessary to the full presentation of the case, which the state is entitled, particularly since the state is relying heavily on circumstantial evidence. I find that it is so intimately connected with and explanatory of the crime charged with the theory that the state is seeking to prove, that proof of it is essential to complete the story. Our courts have further declared that where the full presentation of the evidence is admissible, that there is no reason to fragmentize the events under inquiry by suppressing parts of the res geste. Further, in State v. McGee, the court held that where res geste, evidence of res geste or part of res geste is properly admitted, then no 404B or Lyle analysis is reached. However,
All right,
as to the finding of
1.5.
admissibility of
All right,
evidence,
kick it
which
up a
I
notch.
have done, and the finding of it within the res geste, I've nevertheless conducted a Rule 404B analysis, Lyle analysis, though not needed. In conclusion,
Yes,
the
Tammy, it
state's
is.
motion to admit the other evidence or evidence of other crimes is admitted. I will file a more formal order granting the state's motion later today. Are we ready for the jury?
I believe we are. Your Honor, one point on Your Honor's ruling, I don't know that they're getting into the financial stuff immediately, but we do have a proposed limiting instruction that we would request the court to give at the time.
Hold on, let me slow him down. I don't want to miss it. All right, here we go.
They offer the evidence.
Okay. Yeah, thank you very much. And certainly upon request of the defense, the court is required to give a limiting instruction.
Perfect. Thank you, Tammy,
It'll
so
probably
much.
be late afternoon or tomorrow when we started to cross into some of those financial witnesses.
Oh, Harpoodian is
Have you
pretty mad.
reviewed the defendant's proposed limiting instruction?
Got it right now, Your Honor.
Ah. Oh my God. You know, the poot wants to turn to Griffin and say, oh, I really hate your ass right now. You know he does. Oh, he's big mad. Ooh-wee. All right. Well, this concludes another, I can see him, another fantastic day in court with Alex Murdaugh and the not so dreamy team. I don't know. I can't. I can't zoom in on YouTube. I'm not exactly sure, CB Cal, how that's possible. Kind of explain some things, though. Man, all I keep hearing in my head is, you had a bad day. You had a bad day. Yeah, like, it was a bad day. And it's not going to get better. All right, so I'm going to end this now. You guys go on over to, exactly. All of their balloons were popped today. Oof. And to make matters worse, there's no offer of a new balloon. Like the it clown isn't standing there offering a balloon, They're in big trouble. This is bad news bears all around. All right, y'all go over and check out and go and raid Brittany J's chat. Tell her Jen Lou sent you. All right. Good night, everybody. Thank you all for being here. Welcome to the new members. Thank you for the super chats. Thank you to my mods. Welcome to being a mod, Cement Shoes. Thank you, chat. You guys are all great. Don't forget to thumbs up the stream, and I'll see y'all mañana. All right. Bye.